Hello, everybody. For those tuning in online, hello, and for people in the room, this is our last of the semester series of Lab Talks. Just a quick note about who we are and what we're doing. I'm Yael Eisenstadt. I'm the Policy Director at Cybersecurity for Democracy. I'm based out of NYU. Our co-directors are out of NYU and Northeastern, so we are a multi-university effort that does independent research, really looking at how online systems work and how they affect safety, democracy, public health, all the fun things. We started this series this semester to really help share some of the insights from our research, as well as what the policy implications are. So I'm really excited today. We have two speakers. I'm going to do very brief intros, and then we're going to kick it over to Julia to explain a bit some of her research. So Julia is one of our PhD candidates here and has done a lot of really interesting research around online trackers. Also has done some research around chatbots and all sorts of other fun issues. And she'll be presenting on two different papers that she's recently done today. And then we are really pleased to have Justin Brookman from Consumer Reports join us to also talk through some of the policy implications. He has had many impressive titles, so I'm only going to give a few, but right now is the Director of Technology Policy for Consumer Reports. He was the former policy director of the Federal Trade Commission's Office of Technology Research and Investigation. And earlier in his career, he was the chief of the Internet Bureau of the New York Attorney General's office. So we are so excited that you were willing to come up to New York to join us for this conversation. So the way it will work, I'm going to start by kicking it over to Julia to talk us through some high-level findings from some of her research. And then over to Justin to have some sort of response and thoughts on the policy implications. And then I'm going to lead us in a bit of a Q&A, and then we'll open it up to the audience for questions. So Julia, kick us off.
Ooh, okay, thank you. So are online trackers protecting our privacy? We already heard the answer is no, but I'm going to talk a little bit about how and why not. Okay, so this is work that comes from two papers. First, we're going to talk about what online trackers are, how they're not respecting privacy and why that might be less private patterns that companies are using, and also some lies about hashing. And that's from this paper, Tracker Installations Are Not Created Equal. And then pivot slightly to talk a little bit about interactive advertisements and how our privacy is also not being respected there. Okay, so first, just for anyone unfamiliar, what we mean by online trackers are snippets of JavaScript code installed on websites. Two of the most popular are owned and operated by Meta and by Google. And generally, they capture metrics about website visitors. So this is things like how many people have visited a page, what times a day have they visited, but they can also offer marketing services. So I've gotten success with website visitors who bought my products. How do I find more people like this in some way? But to answer those kinds of questions, of course, you need PII. You need to know who your website visitors actually are. And so this is kind of what the trackers can facilitate. So how do they violate our privacy? They use form data collection to identify us to Google and Meta and whoever's running the tracker. And the way that works is pretty much the way it sounds. So you fill out a form on a website. It can be a contact form, login form, make an appointment form, anything like this. You click submit, that data goes to the website, which is what you think is going to happen. But then it also goes to Google or Meta or whoever operates the tracker in a hash. And the fact that it's a hash will be meaningful later. So why is this potentially bad? Well, one thing, it's not something you know filling out a form. You can't see, by the way, this data is also going to Meta or Google. You can't necessarily opt out if it's a login form for a website you need to use. You can't just not log in because you don't want Meta to know. And also it can be used to collect sensitive data. And this can mean either that the fact that you were on a website was sensitive or that actually some of the fields in the form are sensitive. And by sensitive here, we're defining it as data legally protected in the US. And so that's health data, which is protected by the Health Insurance Portability and Accountability Act, or HIPAA, and finance data, which is protected by the Grail-Leach Blackley Act. So the thing is, you don't actually need to collect form data in order to use these trackers. And so kind of the crux of the research was, well, why might websites be doing this? How often might they be doing this? Particularly for websites that deal with this kind of sensitive data, operate in health and finance spaces. Okay, so one reason is less private patterns. And so by this, we mean the ways that Meta and Google sort of encourage websites to use form data collection when maybe they wouldn't otherwise. So to explain this, first we're going to take a step back and say, well, how does an online tracker show up on a website in the first place? You have a website administrator. This might be someone from an IT department. This could be a third party if it's contracted out. And they kind of peruse the online documentation that says this is what online trackers are, this is what form data collection is, and then they go through this interface for setting it up and installing. And so essentially the less private patterns show up in the context of in the setup process, the companies, Meta and Google, sort of encourage website administrators to turn on form data collection without maybe discussing the consequences. And so I'm just going to quickly go through two examples. I'm picking on Meta because they were bigger offenders of it, but the paper has Google examples as well. So the first example is in order to install a tracker, a Meta tracker on your website, you kind of go through this 4-step flow. And so Meta actually includes form data collection as one of those steps. And just kind of zooming in on this teeny text. They say things like, you already have the information your customers gave you, like this can help you, this is you making the best use of the tracker. And so we say this is a least private recommendation because Meta is basically saying, hey, you should really consider turning on form data collection, and they don't really have any information here about the reasons it might not be a good idea to do so. And then the second example is, let's say I think, okay, well, I actually do want to know what country my website visitors come from. That would be useful to kind of have that as part of my marketing plan. So I turn on this form data collection. It actually auto selects all of the different fields that the tracker can collect. And so some of the other examples here are like date of birth, email, phone number, so really sensitive things. And so we call this a least private default because prior research has shown, particularly dark patterns research, that when things are auto-selected like this, people are a little bit less likely to actually turn them off. And so we actually found in our study that 62% of websites that have the Meta tracker installed do in fact use form data collection, and also 30% of health and 20% of finance websites that turn on the Meta tracker include form data collection. So obviously this is less often than the general population, but still a meaningful amount. Okay, so the second reason that, or the second way that our privacy is not respected by online trackers is lies about hashing. So I guess quickly, in case anyone's unfamiliar, hashing is a function that basically takes plain text, like my email, julia@gmail.com, which is not my real email, and puts it through a function and out comes something that's gibberish, and I can't figure out what the email was from that string. But importantly, it's the function works the same way every time. So if I hash my email and Meta hashes my email, it can match those strings. So Meta and Google say things like, we hash customer information to protect user privacy. We're sending hash data in a privacy safe way. But that's not true, because if I go to a website and that website sends a hash of my email to Meta or Google, and Meta or Google already has my email and hashes it, they can match and say, aha, we know her, that's Julia. And in case this is kind of a bad explanation, the Federal Trade Commission said hashing doesn't make your data anonymous in 2012. And they actually doubled down again in 2024 and said hashing still doesn't make your data anonymous. So it's really, really true that it does not make your data anonymous, but this is still what the documentation says today. So if you're a website administrator that maybe doesn't understand how hashing works, you can imagine reading this, you might assume it is sufficient for privacy. Okay, and then finally, to like pivot away from online trackers slightly, the last thing we want to show is how our privacy is not respected in online ads. And this is work that's applicable to Meta, so Facebook and Instagram, and also TikTok. Okay, so the context for this, how do ads show up on these platforms? Pretty straightforward. You say how much money you want to spend on your ad as a company. You set some targeting criteria. So these are the people you want to see your ad. You can set the criteria by age, gender, income. You can also make it interest-based, and you can get pretty niche and pretty sensitive. And then you say, this is the ad I want people to see. So this is a real example for my Instagram. Anyone who's used these platforms is probably familiar. This content shows up like any other kind of user-generated content. It does have something here that indicates it's an ad. But you can like it and you can comment on it the same way you would anything else. So what happens when you do that? So here, this magazine, they ran an ad and they said, I want people who live in New York and have a graduate degree to see the ad. It shows up on my account. I leave a comment, cool, nice ad. And people who are familiar with these platforms also probably know that when you leave a comment, the comment becomes publicly visible. People can see the text of the comment and they can also see that it came from you. So now the magazine knows, okay, there's this person named Julia and she must meet our targeting criteria because she was shown the ad and she commented on the ad. And not only that, but I, as Julia, I have no idea what this targeting criteria was. So I've identified myself to this third party, but I don't know what they actually know about me. And as I mentioned, this targeting criteria can be pretty sensitive. And so then this is just the thing that Meta says on their documentation related to interactive ads. They say, we do not tell advertisers who you are or sell your information to anyone. This has always been true. But as we've seen, the minute you comment on the ad, they tell these advertisers your name, some amount of targeting criteria about you that you don't even know what it is, and they also show your user profile. Okay, so to sum up, online trackers do not protect our privacy. They use less private patterns to actually encourage companies to protect our privacy even less. They rely on lies about how effective hashing is or ineffective, and online ads also don't. So now I'm gonna pass it over. Yeah.
Thank you, Julia. Thank you.
So yes, I'll just a couple of thoughts. I really enjoyed reading the papers. The first one I thought was really interesting, looking at the roles that Google and Meta can do to kind of nudge folks into doing more sharing. Because you've read some of these stories like, oh, health.com got caught sharing with Google and Facebook, and it's a big deal, and everyone yells at health.com, and then like 2 years later, there might be a settlement, a case against health.com. But largely, like Google and Facebook kind of get away with it. And often there's like a quote from a Google representative in the story, and Google's like, "Well, we don't want this data. We told them not to share it. They're not allowed to share PII, so like that's all their fault." But so it's really interesting to see like the choices, like the nudges they do. I do a lot of looking at Google's and Facebook's consumer-facing privacy controls, which are super annoying and tedious and deceptive, I would argue. So it's interesting that the ones they set up for publishers might do the same thing. And so I think it's kind of like a broader look about the role that platforms play, like in general, like for tech policy, platforms like going back to Section 230, platforms are not responsible. This is how people use them. We're just a platform. You can use this to track or not. It's your own choice. We bear no legal or moral responsibility. And for privacy cases, like again, that's mostly been true. Most of the privacy cases are against the publishers of the health.coms of the world. Health.com's an example. I don't know. Health.com's probably a real website. I don't know they did anything. But I think increasingly policymakers are looking at the role that platforms do play. So privacy is one, and I think we'll talk more about some of that over time. We started to see more cases, not just against the publishers, but against the ad tech companies too. And there's a couple cases that are relatively recently that maybe some of the things that the ad tech company says to publishers were relevant and holding them liable, but like there's other areas too. So fraud, like Facebook, massive platform. There's a really amazing Reuters story at the end of last year, or a series of Reuters stories about how much of advertising on Facebook is for fraud. It's like 10% of their global revenues are from fraud. Absolutely like astounding. And Facebook's internally the document said, well, we don't have big legal responsibility for it. And there's some case law that largely says that, but we're starting to see people trying to push back on that. Actually, I think Consumer Federation of America sued Meta yesterday in DC court over that, saying that they had some legal responsibilities for it. We wrote a letter to the FTC saying that notwithstanding Section 230, they have some legal obligations for it. And we've seen legislation. Bipartisan legislation from Senators Gallego and Moreno to clarify that advertisers have legal responsibilities. In New York State, a bill from Representative Boris, who's done some regulation of AI. So again, more efforts kind of chip away at the idea that the platforms are just neutral standby companies who happen to make like a zillions and zillions of dollars from it. One other area, and then we'll probably get more into privacy that I've been thinking about is AI tools. Like, what responsibility does like ChatGPT or generative AI tools have for how people can abuse their systems? So we actually, the FTC did bring a case against a company called Writer for this. They were they wrote stuff, but you could also tell it, write me 100 fake reviews for my company. Like, oh, here are 100 fake reviews for your company. And the FTC said, well, this is just basically set up for fraud. There's no reason any normal person would need to write 100 reviews for something. And so therefore, that was an unfair business practice. But then, like, actually, then the Trump FTC, the commissioner at the time, disagreed with it. Then he became the chair, and he actually retracted the settlement and said, no, they're just there's the platform. People can use them for good or for evil. We actually did a look at generative voice, how easy it is to like take a YouTube clip. I'm on YouTube right now. You could take a clip of what I say, please don't do this, run it through any of these online free platforms and get it to say whatever you want. There are things they could do to make that harder. They don't. They, I think, have told us they think that they have immunity from that because it's how someone chooses to use it. But obviously, they make choices about how easy it is to do this, to not collect data, to not put up some speed bumps. So I think consistent with this about, that it's not just like one party. Lots of intermediaries have largely fallen through the cracks responsibility-wise. And now, maybe belatedly, we're starting to try to retrofit legal responsibilities for some of these companies.
I have so many questions. I know we're going to dig in a bit into sort of the FTC and some of the reasons why what seems like obvious enforcement is not always happening. But I'm going to start with a few follow-up questions to Julia. Maybe you can just start by telling us a bit what inspired you to do this particular research.
Yeah, there was actually a lot of great reporting, I think, that came out of the markup, and that was sort of looking at specific websites, specific health websites or finance websites that were doing this. And so then we kind of wanted to see if we could measure it on a bigger scale.
So I assume most people in this room are technically in the weeds enough to really understand the implications. But for those watching who might not be, I'm wondering if you can sort of explain to us. I could see, even before I read your paper and I started getting into the details, I grappled a bit with, so what does that mean for me as a consumer? Like, why does this really matter? And I'm talking about the trackers piece. So, can you give us an example of how your findings from that paper could impact anybody, really?
Yeah, so I think one of the examples we talked about before was if you, let's say, at some point end up looking for addiction resources for whatever reason, and maybe you fill out contact forms to get in touch with companies, so you enter your email so that you can be contacted. That then gets caught up in the system, and so beyond just the Meta and Google now knowing that you search for these resources and potentially serving you targeted ads on top of that, there's also other ways that information could potentially get used against you in the future, maybe without your realization even, and this could be many years after the fact.
Yeah, I think people really don't get that. Like, you're searching for addiction resources to help a problem that you have that should be very private. And then is that information going to follow you around the internet because of this? Yeah. Also, maybe one other thing you can sort of spell out a little more for people. You and I, my first reaction to your paper, as you might recall, is like, oh, there's dark patterns all over this. And as someone who has, spoken to Congress over the years about dark patterns and why are dark patterns legal, and there are people grappling with what to do about it. Can you help just explain a bit more, maybe provide an example of a dark pattern and what that might mean from your research?
Yes. So I guess some of the examples, right, were these like I think bad defaults is the word they use in dark pattern literature, of just like setting things up to be by default without you touching anything, collect as much data as possible, and so then the onus is on you as the consumer, or in this case as this administrator, to actually kind of go through and manually uncheck every box and understand which boxes need to be unchecked and why they need to be unchecked, and does it really matter if you do or you don't. And so, yeah, that kind of thing, which shows up in a couple places in this context.
Yeah. Okay, so Justin, over to you. I have a few follow-ups here, but maybe just at a high level, we can start with maybe some of the approaches that organizations, including your own, have sort of advocated for in this area, whether legal or legislative.
Yeah, so obviously the problem with online tracking has been there forever. Some people call it the original sin of the internet. Cookies were not really invented for this reason, but then they could be used for that. And then we've had like a massive third-party online tracking ecosystem for years. Back in the 90s, people I remember Epic tried to sue DoubleClick, then became Google for this in federal court, arguing with wiretapping. And then I think the court said, well, no, the New York Times decided to share this with Google. So that's not why, just one party consented to it, so it's totally fine. So we've been trying ever since to put the genie back in the bottle. People have advocated for different approaches for years. I think U.S. policymakers, again, for a while, was just the notice and choice. People are deemed to have consented, but obviously no one really consents to any of this. Now we're starting to see about half the states have laws governing this, but they largely just rely on opt-outs. You have to kind of affirmatively go out of your way to say no. But that's kind of tedious to go to each website. We actually ran a study when the CCPA first passed. It said, okay, just go to one data broker and opt out of what happens to your data. And it took you 45 minutes, and they had to accept cookies to go there, and they had to fax in a driver's license. This is ridiculous. So opt-out is not really workable. Traditionally, advocates have argued more for opt-in. That has its limitations too, because then that's constantly annoying. If you ever surf the web while you're in Europe, and increasingly in America too, every web page you go to says, "Okay, let's make some privacy choices," and then you need to pull the levers and click everything, and then some places, speaking of dark patterns, make you scroll through hundreds of individual companies, and so that's annoying too. I think in general, advocates have been pushing more for data minimization, which is just it works by default. So I go to NewYorkTimes.com, for example. What they need to process for my being there, to go to the story, to share with some limited parties for some reasons, that's fine. I don't need to agree to cookies or make choices. But then everything else is largely prohibited. So I would love to see all sorts of online ad tracking prohibited, but we've had more success on sensitive data. Actually in Maryland and Oregon, their comprehensive privacy laws say, no matter what, you can't sell sensitive data or share sensitive data for targeted advertising purposes. Actually, just last week in Virginia amended their law to say that geolocation, which is sensitive data that says where you are at all times, you're forbidden, right? No opt-in, no opt-out, no choice, because otherwise it does become a constant tedious game, and the companies who can set the interfaces can just kind of beleaguer us into submission.
So before I move into my onslaught of questions about the FTC, which I have multiple questions, I have fallen behind in where we are on dark pattern bills on the Hill, and I don't know if that's something you follow in particular, but I know for a while there were some bills, and I know dark patterns can be perhaps difficult to define at a granular level, and that's where a lot of tech legislation gets caught up, because then they say, oh, by the time you pass this, it's outdated. What do you think about dark patterns in particular? Is there something there?
I think there's something there. I think it's also at some level just what's happened since time immemorial. Is still just I think it's just all variations on deception, right? So commercial deception has been governed in this country since the 1930s, whenever the FTC statute got augmented from just competition to more consumer protection stuff. And so a lot of this, what we call dark patterns, I think you could was traditionally just called deception. I think it is hard to specifically regulate and micromanage dark patterns in general. But the FTC has tried, even before they used that term. When the internet came around and companies have more and more ability to constantly tweak things and push the envelope a little bit, they put out a document called the .com disclosures, which they've updated a couple times since, that basically says, okay, if you're presenting an offer, maybe make the choices about roughly equal. Don't hide the skip in the corner, and then when your mouse goes, it runs away. So there are guidance, but it's hard to know exactly when does it cross the line into deception. Because again, it's definitely shades of gray. I mean, the thing around hashing is interesting because, I think Facebook says we hash to make it more private. Well, it maybe makes it a little more private, right? The FTC, didn't say that it doesn't do anything. They just said it's not sufficient to really anonymize data. Google's was a little more one-sided, that this is a privacy-friendly way, and maybe you can say, well, it's not really privacy-friendly, but it is tricky to and then the vast majority of FTC cases are settled. To actually prove that in a court of law, they need to get they need to hire a user group and say, what do you think when it says this? It becomes actually really difficult to enforce in practice. Also, B2B deception is not generally covered, because again, if you think about kind of tricking consumers, right? Tricking a company into hoovering up more data, like FTC might argue that's not really our problem. We protect consumers from individuals. There have been some cases that have covered B2B, and again, it does have a real effect on people. It is deceptive behavior, which does end up having harm, but it is a little different than the way they've talked about it. I think the actual FTC policy statement does say it covers deception to consumers. I'm not sure how legally binding that is, but that is how they've traditionally thought about it.
So before I get into some more specific questions about the FTC, Julia, I know that when you and I were talking about the paper, you were surprised that hey, how come the FTC isn't doing anything? I'm curious, what really I might have just answered the question myself there, but what really surprised you as you did this research? And also, you had some recommendations, I think, for consumers as well. But would love to hear a little bit more about, when you realized that the FTC had already said hashing is not private. What were some of the things that caught your attention?
Yeah, it was pretty surprising. The FTC said it in 2012, and here we are, and we did 2024, 2025. And I think to your point, it's not necessarily that they're one of the things we thought could be a way to manage this would be just the language in the documentation feels so blatant and misleading. And so it's not to say that hashing isn't good or that hashing doesn't have a place, but the way they talked about hashing. I think for consumers, there's definitely browsers that are better that try and block some of these some of the data sharing, and that's probably the best way. We had as part of this work put out a Chrome extension that would at least show people who was behind the scenes and potentially listening and collecting data. But that's a lot of an onus to put on a consumer. And as we talked about, you can't always not fill out a form anyway, so it almost doesn't matter at that point.
Yeah, it won't surprise anybody that I'm one of those people who believes that putting all the responsibility on the user for something that's A, kind of hard to understand at times, and B, already deceptive is a lot. So let's talk about the FTC for a moment. I'm gonna mash multiple questions into one here.
All right.
So Julia's paper her presentation showed exactly where the FTC was nope, this is not privacy protecting, and then Meta still has that statement, I assume to this day, that claims that they are doing everything to protect your privacy. I guess my first question, I'm gonna give you two questions together. My first question is, what could the FTC do to actually protect consumers more against whether it's the issue she pointed out in the trackers paper, or also the issues from the advertising paper, where there clearly are ways to see the targeting information and individuals, which Meta claims they are completely not doing. Mm-hmm. So the first question is sort of, what could the FTC do? But then more broadly, what are some of the pitfalls for the FTC? Why is it so hard for the FTC to be able to enforce some of the things that many of us probably think sound obvious? What's going on there? Why are they having such a hard time on some of these issues?
Yeah. So first of all, FCC doesn't have a privacy law to enforce, right? So they most countries around the world have a privacy law. The FTC does not. The FTC also has been historically beat down by Congress. Anytime they've gotten more aggressive, and then their funding stripped away. The biggest was toward the 1970s. They started talking about the harmful effects of advertising for kids, which, looking back, was maybe kind of prescient. But then they had their funding cut in half, and then their authorities were taken away. So even if today the FTC finds somebody and finds them clearly breaking the law, they often can't find them. They don't have finding authority in most cases. In many cases, if someone steals money, they don't even have the legal authority to make them give the money back. So the FTC has been set up to fail in a number of ways. They have a privacy division. They have 50 people in it. They're really great. They're really strong. But also, they also have a lot of internal barriers in order to bring a case. They need to jump through a lot of hoops. They need to share it with the Bureau of Economics. They need to get someone else to weigh in. It just takes a long time. And if it's litigation, right, proving cases is hard. So when I was at the FTC, there are a couple litigations going on, and those take 20 attorneys each. And so then you got 10 left for everything else. So that becomes tricky to enforce privacy without having a privacy law in place. And so again, the law that they usually traditionally have enforced, is basic consumer protection law dating back to the 30s, prohibition on unfair and deceptive practices, and deception's how they've done most of it. Unfairness is a broader term, and again, back in 1980, when they got mad at the FTC, they narrowed the definition of unfairness. But the FTC is now using that more in privacy cases. I'm going to talk about that in a second. But most of what privacy cases would be is you said something in your privacy policy. I'm not going to share sensitive data. You sold sensitive data. That's our case, right? So there's a lot of gotcha based on those things. And a lot of the things you talked about, you mentioned the GoodRx case, BetterHelp, and lots of these cases traditionally have been like that. Again, on GoodRx, which was the company that had the privacy policy, the company with the relationship with the person in a position to lie. So that's why they were held responsible. But then the FTC has brought some cases against ad tech companies for their lying, mostly for having broken opt-out policies. So most companies, as part of self-regulation, say, hey, yeah, you can opt out of us. But you'd be surprised how often those don't work. So in a lot of their cases, they said, you said you can opt out, you couldn't do it. So that you guys are being deceptive, despite the fact that no one really goes to your website to try to do that because no one's ever heard of you. But there have been a couple more cases more recently, which I read these cases more after reading your paper to see, did they ever kind of get after ad tech companies for kind of helping, kind of nudging someone else to lie? And a couple of the ones actually toward the end of the Khan administration, the Biden administration, Lina Khan, did go after some of those companies. So they brought a case against Gravy Analytics, online ad tech location sensitive data hoovering up company. But they provided hey, here's an example of a notice you can show to your users. And it was didn't say anything. It was totally deceptive. And Xmode, again, a case against Xmode, online data broker, ad tech, collects sensitive data. They also said sample notice, hey, we collect data to optimize stuff, which was not very clear at all. And so that was there they said that by providing those, you were helping to deceive. I'm trying to think how it was phrased, but there was kind of similar to what you started to get towards some of the things you showed in your paper. You were kind of nudging folks a little bit to put your thumb on the scale for more tracking in ways that were a little bit deceptive. But overall, a lot of their cases are moving away from deception because they are kind of gotcha cases. And then in response, most companies just don't say anything interesting in privacy policies at all. It's no one's going to read them. If the only way we're going to get in trouble is to say something in privacy policy, we're just not going to say anything interesting. And so increasingly the FTC is saying it's intrinsically harmful to share sensitive data. So sensitive data we're putting on a pedestal. That's location data, health data, those sorts of things. So that if you collect and share that without permission, without the affirmative consent, we're going to call that harmful. And again, first they started with the publishers. I think the GoodRx, probably the unfairness case in there. I worked on a smart TV case, Vizio. Vizio was then sharing everything you watched on your screen with advertisers. That was considered unfair, according to the FTC. But then some more of these cases are now starting to go after the ad tech companies too. So the FTC is suing data brokers like Kachava for collecting geolocation information. And so again, but then the question is how can a third party get consent, because no one has any idea who these companies are. And I think that's when the FTC says, well, you're kind of you either know about examples or you have it, and you're not doing anything about it, or you're giving people bogus interfaces where that's not actually going to inform them about how it works.
So I'm just going to wrap with one more question. I want to give lots of time for Q&A from the audience. I'm also, as I'm hearing you speak, I'm hearing so many opportunities for more research and future research. So hopefully, research that impacts this space is really important. So I'm thinking, it's a little devil's advocate, right? Because if the FTC did go after more of these companies for deceptive practices, one might argue that the companies will just be less transparent in the future. We've seen that argument in various ways from some of these companies, like, oh, you want to expose all our research, we'll stop doing research. So, I mean, in part, do you buy that? But let me get even more specific. So in these recent jury trials, right, you had Los Angeles and New Mexico. One of the aspects that got a lot, it might sound like I'm shifting a bit, but it's still on this idea of deceptive practices. One of the aspects that got a lot less press attention is that Meta was really found guilty of essentially lying about their safety measures, right? It was that they were lying. And thinking about Julia's paper, where it says that Meta promises not to tell advertisers who you are or sell your information to anyone, clearly a lie. Do you think a verdict like New Mexico might finally help incentivize companies to change either whether it's some of the design issues or be at least more forthcoming in their communication to users about these risks?
I think, obviously the wave of litigation that does, I think, put the fear of God into them more. But I think it does also then incentivize them to then make fewer promises about safety. This was the thing when when I was at the New York Attorney General's office, we did bring a case against Meta, Facebook. Meta didn't exist yet. For, again, overrepresenting how easy it was to get help. This is still pretty early on in Facebook's existence, but we had heard a lot of complaints about people soliciting underage users. This is the thing when they're moving from like just the university model to like anyone can do it. And like they scaled up super quickly and they're making lots of money, but their safety systems did not scale up and have never really caught up. But we did rely on the fact they said, hey, if you complain within 24 hours, you're going to hear something, and we did lots of undercover accounts, so they didn't. Again, that was a settlement, and they had to pay money because of it, but obviously it wasn't enough to really incentivize them to sufficiently invest in trust and safety, which they never really have done. Actually, we didn't talk about your second paper as much, where like they do say pretty clearly, your advertisers aren't going to know who you are. I think they already got in trouble for that. I think there's FTC. I think 2011, the first case against Facebook, based on like the first Facebook rejiggering of their settings that led to everyone sharing a lot more. But I think there was a count in there where they went after just this exact thing, where they said, you say advertisers are not going to get data, but then when someone clicks on it, they totally get data. So it might be worthwhile like looking at that. We should look at it after this. And then you have all the more reason to go to the Federal Trade Commission. Like they signed a paper saying they were going to stop doing this specific thing, and yet when we spent $50 on Instagram ads, we were able to demonstrate people doing it pretty easily. I mean, again, you kind of. Again, regulators are strapped. It's really hard. It's a hard job in general, but that's a pretty straightforward violation of an existing order. And the one thing assuming everything it was true, but when there is an existing order, then they can get fines, right? That was why Facebook had to pay $5 billion of fines in 2019, which maybe is not enough to really incentivize Facebook, but it's because there was a prior order saying you're going to stop doing this. So again, I think they would be interested to see if the very thing that they were told to stop doing, but TikTok too. I mean, TikTok is I think under some standing order. I don't know if their promises would relate to this as well, but I think it is kind of depressing that an issue we thought we had established like bright rules of the road, like 20 years, well, not 20 years, so the order's still in place. The issues never go away.
So follow-up noted, share our paper with the FTC. All right, I don't know if people are watching online, have questions they can put in the chat, but let's open it up for Q&A.
I have a question. So we talked about why maybe dark patterns or deception would be hard to bring forward a case on. However, like Julia's presentation started with like HIPAA, and have the health and finance websites are still collecting data, even though that's a clear violation of those two. I don't remember the other one, the financial one, but mainly HIPAA is what I know. And like we have to go through extensive training on HIPAA, so you'd think these companies would be pretty well versed on that. But would that be something that would be an angle to bring a case on, or why is that something that hasn't been done yet?
Yeah, so I think I think it's hard to specify the exact dark pattern. But I mean, like deception, like it is hard to prove in court, but it does, like, it is the law, and it is the basis for lots of these, and like there's a robust, like, body of law out there. The FCC does push that pretty aggressively. On HIPAA specifically, I think most of these websites that are caught doing this, while they do collect health data, they're not HIPAA regulated. So HIPAA is actually kind of a smaller, narrow piece of like doctors basically going back and forth. If you like Google WebMD and ask why does this itch, like that's not covered, right? Now that said, now the FTC has there was an element of HIPAA that was regulated, and the FTC interpreted to mean more broadly that sharing health data without permission is a violation of a breach notification rule. And so I think I think it was against GoodRx, they mentioned that as a kind of expanded use of HIPAA to cover other situations. I think I'm forgetting some of the details. But in general, the FTC and have said that health law, whether you're HIPAA, whether you're a doctor or not, is treated as sensitive data, and therefore you need to get affirmative, real consent to do it. There's also, we didn't even talk about, FTC enforces Section 5, the unfairness and deception law. That about half the states now have their own state privacy laws. Most of those say that sensitive data can only be processed with affirmative consent. But that's kind of all it says, right? Sensitive data can only be processed with consent. No one knows what it means, and there's been no enforcement of any of these provisions. So, like, if I go to a website and type in my conditions, that's arguably consent to the company. But I think some of these companies will then say, okay, we have consent to do whatever we want, right? And so there's just not a lot of parameters and not a lot of enforcement and not a lot of clarity as what that means. But all the more need for enforcers to start putting some meat on the bones there and say, no, just typing in something does not mean that you are consenting to anything that can happen with this company down the road.
Actually, and forgive me for if I'm asking you a question that you weren't ready for, but I believe you actually had an example in your paper from some of like the HIPAA question.
We had some health websites, that I don't know if they were technically covered by HIPAA by this definition, but they definitely dealt with health data. So they were health industry. But yeah, I don't know how.
And they were using some of the defaults,
They were
right?
using the defaults that were collecting form data. Yeah.
Yeah, I think regardless if they're HIPAA covered or not, they should not be doing that. I remember there was one case where there's a health website, they had a HIPAA seal of approval in the corner. It said HIPAA certified. Like, HIPAA doesn't cover you. And no, HIPAA didn't say this. Or HIPAA. Like it was just like an obnoxious thing, and that was actually one of the FTC's counts. Like it's like the presence of this confusing seal to imply that you are heavily regulated and blessed by someone is inherently deceptive.
Yes.
Yeah, one thing that I wanted to note about that might make also, like, I'm not sure whose responsibility it might be, because both Google and Meta, when you set up the pixels, if you are an advertiser, they ask you if you are a health or a website, for example. Right. And if you select that, then the defaults are different as far as they go. Of course, they don't tell you why that matters and everything. So in that case, would it be more the responsibility of the website, let's say, or legally speaking, or?
Yeah, I mean, I think the primary responsibility on the website, I mean, I think you can make an increasingly sophisticated / aggressive argument that, like, depending on how it's set up, like that Google and Meta have some legal responsibility as well, but it is harder to make that case. But you're right, like, as you say in the paper, like, they don't tell you why it matters. They don't say, hey, if you don't click health, you're going to be breaking all these laws, right? And so, like, that's a choice they make, but maybe they're not sufficiently incentivized to do that. But also, like, again, on the state privacy law that says, like, you can't process data without consent. I mean, that applies to everyone, right? So now Google is arguably can't touch sensitive data without consent, and Google doesn't really have Google or like all these hundreds of other ad tech companies. No one knows who they are, and so, like, how does Google get consent for that? Do they get it through health.com? Do they, in their general purpose Google privacy policy, when you sign up for Gmail, is there a waiver in paragraph 50 saying, by the way, you consent to us collecting whatever? Is it something else? I mean, I don't know. There's no clarity under the law. It's a nice thing for the states to say you can only collect this with consent, or they might just say, we're a service provider. We're not. We don't control what happens to this. We're just acting on behalf of our friend health.com, and therefore a lot of these laws don't apply to us. And I think some ad tech companies have said that in response to the state privacy laws. But it is really astounding how there is so little certainty as to what all these new laws mean.
As I've heard you talk about some of the issues around enforcement, I think one of the things that I think a lot about is, so you mentioned, maybe the right path is to pass laws around data minimization. But then I was thinking about, well, how would we ever validate compliance? I think, I think, right, this is a process that's inherently not transparent to the end user. There are things that, people in this room can do to study these kinds of questions, but again, everyone in this room knows how challenging that is. And I feel like the FTC, you have mechanisms to compel disclosure sometimes, but there's a lot of guardrails around using those. And so I guess I'm thinking about, for any new privacy law that, that might give the FTC more authority, what kind of enforcement mechanisms, enforcement powers do you think would be needed so that that law would actually have teeth?
Yeah, that's a great question, because, like, a lot of times these laws pass, and often they're often like riddled with loopholes, so, like, not all sharing